May I come in, sir?
आइए.
Thank you, sir. Good afternoon, sir.
यस, बैठिए.
Thank you, sir.
इंटरव्यू की डेट नहीं आई सर. यस, 10th 12th आपका कहाँ से हुआ?
Sir, 10th I've done from Kendriya Vidyalaya BSF Jodhpur
हाँ.
and 12th from Sohanlal Manihar Jodhpur.
जोधपुर. ये जोधपुर जो शहर का नाम है आपका, ये कैसे पड़ा जोधपुर?
Sir, on the name of Rav Jodha ji, he established Jodhpur.
In which year the Jodhpur was established by the Rav Jodha?
Sorry, sir, I cannot recall the year.
What is the name of the fort of Jodhpur?
Sir, it's Mehrangarh Fort.
And situated upon the which hills? What is the name of the hill?
Sir, it's Chidiyanath ji Hills.
Who was Chidiyanath?
Sorry, sir, I am not aware.
Okay, you heard about the Ladu Nath.
No, sir, I have not.
Okay, what do you know about the Mahamandir?
Mahamandir?
हाँ.
Sir,
the
I
Mahamandir is concerned to the which society, etc.
Sir, I'm not aware.
You heard about the Nath Sampradaya.
Sorry, sir, I have not.
Okay. Who is the district and session judge of the Jodhpur Metro?
Sir, I have read the name, but it's not coming to my mind.
Okay. What are the differences between the metropolitan system and the other system, other than metro, in respect to the judiciary and police?
Sorry, sir, I'm not aware.
Okay. Who is the Chief Justice of the Rajasthan High Court?
Sir, Honorable Justice Shinde, recently appointed.
Okay. And now the latest news in respect of the election of president, and what name proposed by the ruling party and what by the opposition?
Sir, the name which has been proposed by the ruling party is of Lady Murmu. Sorry, sir.
Srimati
Srimati
Draupadi
Draupadi Murmu.
Murmu. And opposition proposed the name of candidate for election of president.
Sir, I'm not aware of the name suggested by the opposition party.
Who is the Chief Justice of India?
Sir, Honorable Justice N.V. Ramanna.
M.V. Ramanna. Okay. And who is the chairman of State Women Commission?
Sir, I don't know.
Okay. Who is the chairman of the State Human Rights Commission?
Sir, I don't know.
Which subject you prepared very well? Anyone?
On the law subject, sir?
Yes.
Sir, I have prepared CRPC and CPC.
Sir, पूछे.
Okay, tell me statement under section 164,
Yes.
is it mandatory and in which cases it is mandatory?
Recording of the statement under section 164 is mandatory in respect of the which offences?
Yes, sir. Sir, under section 164, subsection 5A, the offences referred to are the offences of rape, in which the recording of statement is mandatory.
Only
Not in respect of the 354 ABCD, 376 A,
Yes,
B,
sir.
C, D, D, 509.
Yes, sir.
then it can be said offences against women, sexual exploitation, sexual offences.
Yes.
Okay. डबल जियोपार्डी के बारे में कुछ बताओ. क्रिमिनल लॉ के स्टैंड.
Sir, our constitution in Article 20, Clause 3 recognizes the doctrine of double jeopardy, and the same has also been given statutory recognition under section 300 of the Code of Criminal Procedure. The basic idea is that a person should not be put twice in peril for the same offense.
ओके, तो एक आपको मैं प्रॉब्लम रखता हूँ.
Yes.
एक एक्यूज्ड है जिसका ट्रायल चला 325 IPC, ठीक, और उसने अपना जुर्म इकबाल कर लिया, ठीक, कोर्ट ने प्रोबेशन दे दिया, ये फर्स्ट हियरिंग पे हुआ, ओके। कुछ ही दिन बाद उसी चोट से वो विक्टिम जो था उसकी डेथ हो गई। अब उसके विक्टिम के लीगल हेयर या जो भी उसकी तरफ से पैरवी करते हैं, वो एक दरख्वास्त लगाते हैं कि साहब मर्डर का ट्रायल चला, तो कैसे पॉसिबल है, क्या तरीका हो सकता है?
So the trial of the convict for the offence of murder is possible. Section 300 CRPC does not bar it because the consequences had not happened that time when he was convicted for the offence of grievous hurt. So he may be tried for the offence of murder.
तो क्या करना होगा उसको?
I beg your pardon, sir.
जो उसका लीगल हेयर कोर्ट के सामने आया, उसको क्या करना होगा?
Sir, I cannot say it with certainty.
एक्यूज्ड के एब्सेंस में ट्रायल कब हो सकती है?
So accused की absence में trial हो सकती है under section 317 of the CRPC when he disturbs the proceedings in the court, and also when his personal attendance has been dispensed with when the magistrate issues a summons under section 205 of the CRPC.
और एब्सकॉन्ड हो गया एक्यूज्ड, तब भी कोई प्रोसीजर है?
So section 299 of the Code of Criminal Procedure provides the procedure for recording of evidence in the absence of an accused person when he is absconding.
बयान मुलजिम क्या है ये?
Bayan mulzim.
बयान मुलजिम is concerned to the which provision of the CRPC?
Sir, I believe section 161 of the CRPC. Statement of the accused is recorded under section 313 of the Code of Criminal Procedure.
Whether the bayan mulzim or the statement of accused recorded under section 313 CRPC on oath?
No, sir. Oath is not administered to the accused.
Oath may be administered to the accused under any circumstances.
Oath may be administered when the accused offers himself as a witness in writing under the provision of 315 of the code.
Okay. When a first class magistrate conclude the trial and convict a person with 2 years imprisonment, appeal is filed to the appellant court for the enhancement of the punishment. Whether the court of session may enhance that sentence to the 5 year if the prescribed punishment is 7 year for that offence.
So the Court of Session cannot enhance the punishment more than the limit which the magistrate could have imposed on the accused. That is the principle contained in section 386 proviso.
Okay. Whether revisional court may set aside the order of acquittal and convict the accused person?
No, sir. This is a restriction imposed on the Court of Revision, and acquittal cannot be converted into a conviction.
What are the grounds of the appeal for victim? Upon which ground the victim can prefer the appeal before the competent appellant court?
So the proviso to section 372 of the code provides the grounds on which an appeal may be preferred by the victim. The grounds are inadequate compensation, acquittal of the accused, or conviction for a lesser offence.
When in NI matters, the special magistrate to deal with that NI matter pass the order of the acquittal, appeal lies to the which court from that order?
So I believe the appeal lies to the Court of Session under the provision of 378 of the Code of Criminal Procedure.
Sub says that the appeal shall lie to the High Court with a special leave under subsection 4 of section 378. What, you are right or the Sab is right?
Sir, I may be mistaken. the appeal under the NI Act is a complainant's appeal, which I believe may be filed under section 378 of the code, subsection 4.
A sister file a application under section 125 CRPC against the brother for obtaining maintenance. First class magistrate may pass the order of the maintenance in favor of the sister.
To my knowledge, he cannot.
Parents are not alive, parents are dead. In that situation, whether the magistrate has power to pass the order in favor of the sister.
Sir, as far as my limited knowledge goes, I am not aware of such provision.
Any relief for that dependent sister is provided under the personal laws.
Sir, I am not aware. It's not coming to my mind at the moment.
What is the limitation period for the filing the application under the DV Act, under section 12 of the DV Act?
Sir, I believe it is 30 days.
From whence?
Sir, I'm not aware.
Okay, what are the nature of the relief conferred under the DV Act, like protection order, residence order, custody order, compensation order, monetary relief? What are the nature of this relief, whether it come under the realm of the criminal law or the any other laws?
So the reliefs conferred by Domestic Violence Act are civil as well as criminal in nature.
Okay. Which judgment of the Honorable Rajasthan High Court is leading upon to this point, that these relief are essence in comes into the ambit of the realm of civil law, the name of that case law?
Sir, I'm not getting a proper recollection.
Okay. When any other order is passed by the magistrate under DV Act, what is the remedy against that order?
Sir, an appeal may be preferred to the Court of Session.
Okay. What provided under section 5 of Limitation Act?
Section
Not as per the Bare Act. General question, section 5 is concerned to the which point?
Sir, section 5 concerns to the entertainment of an appeal or an application on the showing of sufficient cause by the appellant or the applicant for the delay.
Okay. When a suit is filed by a plaintiff and the application is filed with that suit under section 5 of the Limitation Act, he is suffered from the disease and hospitalized for the 6 months, that is the sufficient cause for the delay. Then the court may entertain that application and admit the suit.
No, sir, a suit cannot be entertained with the help of section 5. I think the plaintiff will have to take recourse to section 6. Legal disability will have to be shown.
Not the legal disability is not at the time of the cause of action. He subsequently suffered by the disease, and not that disease which is given disability which given under the section 6, not the minority, insanity or idiocy, other than any other disease.
Sir, as far as I know, section 5 of the Limitation Act only concerns applications other than applications for execution and appeals. So, period of limitation for a suit may not be condoned.
Okay, application shall be rejected by the courts.
I believe so.
Please define constructive res judicata.
Ma'am, constructive res judicata basically means that a person who ought to have taken a ground of objection or defense, but he did not take, he shall not be permitted to take that ground later. It will be hit by the doctrine of constructive res judicata.
What is difference between decree or order?
Anyone basic difference.
Ma'am, one basic difference that I am aware of is that an appeal shall lie from a decree as a general rule, whereas not all orders are appealable. Appeals lie from only those orders which are specifically made appealable by the code.
We can state that the decree conclusively determines the rights of party, but it is not in respect of the order, may or may not be.
Yes, sir. That is the
more
prime difference. Yes, sir.
Define decree.
Ma'am, a decree conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit. It may be preliminary or final.
बैरक से नहीं बताना है, बैरक से हटके बताना है डिक्री.
Okay, sir.
like the operative part of the judgment.
Okay,
Degree
sir.
is operative part of judgment. ठीक.
What is register?
Ma'am, res geste are the circumstances, all the circumstances which constitute a transaction, facts forming part of the same transaction.
What?
साहब पूछ रहे थे आप कुछ?
Yes. Do you know about degree of appreciation of evidence?
I'm sorry, sir, I did not understand.
Appreciation of evidence
Yes.
के बारे में आप क्या जानते हो? ये terminology.
Appreciation of evidence. What do you know about the meaning of appreciation of evidence? साक्ष्य की विवेचना, मूल्यांकन.
Sir, what I understand from appreciation of evidence is that the court ascertains the probative value of an evidence and determines on its admissibility, its relevancy.
And ये भी बताओ कि इसकी कोई डिग्री भी है आगे कि एप्रिसिएशन ऑफ एविडेंस किस लेवल तक का होना चाहिए, कैसे मामलों में
क्रिमिनल और
कैसा
सिविल
होना
में
चाहिए, क्रिमिनल में कैसा होना चाहिए, एक्यूज्ड के पार्ट
स्टैंडर्ड ऑफ द प्रूफ.
स्टैंडर्ड डिग्री.
Sir, appreciation of evidence, the court undertakes in civil cases, the standard of proof is comparatively less. The plaintiff has to prove his case based on the preponderance of probabilities, whereas in a criminal case, the standard of proof is very high. The prosecution has to prove the guilt of the accused beyond reasonable doubt.
और डिफेंस में यदि एक्यूज्ड की डिफेंस में एप्रिसिएशन करना हो तो क्या होगा?
So the accused has to prove his defense on a preponderance of probabilities.
If matter fall under the POXO Act, then
So POXO Act is a special legislation requiring, there are some provisions in which a court is required to make certain presumptions. If the case is covered by those presumptions, then the accused will have to prove his case beyond reasonable doubt.
विक्टिम कंपनसेशन के बारे में कुछ आप बताओ.
Yes, sir. Victim
इसका
compensation.
प्रोविजन कहाँ है और कैसे कवर होता है, कौन प्रोवाइड करता है?
So the provision is contained in section 357A of the code. Compensation is granted by the state government. A scheme is framed by the state government. The quantum of the compensation shall be decided by the state legal services authority or district legal services authority, as the case may be. And as far as I know, an application may be made by the victim, or a recommendation may be made by the trial court for award of compensation to the victim.
आज का न्यूज़पेपर पढ़ा आपने?
Sir, I was traveling today, so I could not.
अच्छा, क्या क्या महत्वपूर्ण मुद्दे चल रहे हैं भारत में?
Sir, the
बर्निंग इश्यूज क्या है पिछले 2-4 दिन में?
So one issue that is the most burning currently is the Agnipath scheme,
ओके, और
and the summoning of Mr. Gandhi by the Enforcement Directorate.
ओके, इन एडिशन टू दैट
Other than that, I am not aware.
the statement given by the Nupur Sharma,
Yes, sir.
whether it is offense under the any provision of the Indian Penal Code, it fall under the any section of the Indian Penal Code.
Sir, I believe her statement may be considered an offense to the religion. It may be covered by chapter 15, section.
Under which provision? The chapter 15 start from the 295 and
Two-
ended on the 298. Which particular section is concerned to this statement?
Sir, I would say 295A.
Okay, and in addition to the 295A, it fall under the 153A or the any other provision of the IPC.
Sir, I cannot say it with certainty.
ठीक, अच्छा है आपका ऑल ओवर, और जहाँ जहाँ अटके उन चीज़ों को